Hello and welcome back to the another episode of daily lectures. To be more precise, as you can see on the screen, it is our third lecture about Indian polity. We had recently started it. If I will be more exact in it, we had just started it from last 2 days. So it is our third lecture. So before we will start our discussion, as I am expecting there could be some new students who might visit it today, maybe they might be seeing this video first time. So for them, let me introduce the initiative so that if they would want this help, they may get connected with us. Basically from 2nd June 2025, we had started an initiative here in which we are covering your syllabus for your UPSC preparation. And if you would had read your syllabus, if you are freshers, then let me tell you, for your UPSC preparation, you need, if I will be very much accurate in it, you need to cover 3 types of things. To be more precise, 4 types of things. First, you need to cover your current affairs, so that at least from last 1.5 years, so that you will have the proper idea what has happened in the world or in the India, and what are its impacts on the society, and how you as an administrator can react to that, how you can solve these issues. So that is the basic nature of knowing the current affairs, how much active you are, how much aware you are of the world what is happening right now, or of the country what is happening right now, or of the state of which you belong to, what is happening in that state. Second thing which you need to be very much clear of is the static syllabus. And this is very vast. This static syllabus is very vast because it is divided into the prelims. There is different parts for prelims, different parts for mains. So it is a very vast syllabus, and it contains large number, I can say vast number of subjects. So this is what you have to cover. Whether in the static part you will have to cover Indian polity, you will have to cover governance also, you will have to cover international relations also, you would have to cover geography, you would have to cover economy, Indian economy, you would have to cover everything, whether it would be science and tech, what is happening, what are the recent researches with respect to that, where you would have to cover what our space program right now is. So everything, whatever where to what direction you look, you would have to cover that thing. So this static syllabus, it is very much given in UPSC very much gives it to you that what you have to prepare for that. So this is the second thing which you have to prepare. And the third thing, for the prelims perspective, you have to prepare CSAT. There would be very basic maths for that, reasoning would be there, and comprehension would be there. So this is for clearing the prelims, you have to cover the CSAT too. And the last thing, which is you have to cover the optional subjects. We may contain the optional subjects in the static part only, but for that's separated, you have to cover the optional subjects too, because if you want to cover if you want to clear the mains, you should have the strong hold on the optional subjects. And for that, either you can study at home, you can go to different coaching institutes, you can download the syllabus, you can watch the topics, and whatever you want to do. So this is the optional subjects. This is the fourth part which you have to cover. Then fifth, it is about the languages, your basic languages, whether you would be Hindi knowing, whatever state you are from, whatever language which is which is accepted by UPSC, then it is cool. So these are the 5 things majorly what you have to take care of. In these 5 important points, this part, this current affairs and the static part, if we will give weightage to this part with respect to the others, it would almost contain the 70% of your syllabus. 70% of your syllabus is under the current affairs part and the static part. This CSAT, very simple, you can cover it from anywhere, it doesn't matter. As about the prelims, it is said, it is just to reject the candidates. How much marks you get in the prelims does not matter, they are not counted in your mains and interview. So CSAT does not matter, it is not that important with respect to the with respect to its weightage to the syllabus, but you have to clear that it is the scoring. In this you have to score above 33%. It is the scoring subject. If you get above 33%, then it is good. Then you don't have to look at it. Then optional, you have to cover it. I will give almost 30, of the remaining 30%, I will give 20% to the optional. If you are not covering your optional, then there are maximum chances that you may never succeed in the UPSC. So this is the percentage. If we will divide your syllabus into the percentage. So what we are doing here, what we will do here, what is this institute about, what is this initiative about, what we are delivering here, what it is about. What we are delivering here, it is about this 70%. So what we are going to do, every day we will upload a video in which we will cover your current affairs. We will cover every important article which is relevant for you, in the newspapers. We'll discuss that article and we will show you how you can connect this article with your prelims exam, and we will show you how you can connect this article with your mains exam, and we will show you how you can connect this article with if may asked in the interview. So this is what we will do. And also the static part, this we are going to cover here. In the static part, first we had started with the Indian polity, and we are planning, it is in our plans that by the month of Jan 2026, we would complete everything, whatever comes in this part. We will complete every subject which is important for you. So this is what we are going to cover. For CSAT, you can go check. There are many, YouTube channels which teach you CSAT. And for optional subjects, you have to consult some, specific teacher for that. And language, you had read, you are very much aware of the language which you have to write in the exam. So that is not an issue. Now here, this is what we are going to cover. Now for who we are covering this? Who are the students who will get, who will get the help from this initiative? Who are the students? There are, if I will be more clear in this, every student who wants to clear their UPSC exam, he will get benefited from this initiative, because it is the way we had created it. It is in a very unique way. When we will cover some, as you would have seen in my earlier classes, we had just given 2 classes of our Indian polity. You would have seen every topic which we cover. What we do at the end, we will make we will derive a possible question from that, so that it will give the idea, it will connect you with the exam. So this is a very unique way. So to whom it will help? Mostly it will help everyone who is preparing for UPSC, but if I will be very much precise in it, it will help those students who are who are busy in their jobs and they want to cover UPSC, who are in colleges and they want to clear UPSC, who are not economically that well, they are not fortunate enough to go to any coaching institute. So for those students, this platform is the best, because we will try to cover everything here. So these are the students who can get benefited. In fact, everybody can get benefited from it, but I am talking precisely for those students. If you are doing the job, you don't have time to join any coaching institute, and you don't want to invest that much in it, you want this thing to be very much freely available to you, so this will help you. And if you are economically, you belong to the economically weaker section, then this will help you. Now this is about the lectures, what we are going to give here. When we give the lectures, for example, I noticed one thing, when we are giving the lectures, there is, we try our best that we will cover everything, every fact will be covered. But there is this human tendency, when you are giving the lectures, you get so much involved with one point that you may forget few points. So what about those points which we don't cover here? For those, for that issue, to this problem, what we are doing, we are making the notes of these videos, we are making the notes of these subjects, totally different notes, in a very different way. I challenge you, here I can say very proudly that the notes which we are making, and if you will compare it with your standard books, you will find our notes will be much understandable to you. You will find that they contain more information related to your exams, and in a very simplest language possible, and also those notes contain questions after every concept which is discussed there, so that it will give you the all time the best idea about the exam. It will make you understand the concept. Those books speak with you. Usually in the books there is the information given, but the notes which we are creating, they will speak with you, they will explain you things, and you will definitely like that. Now you will ask me, sir, please give us the notes. Right now they are not available, because whether as we are developing in our classes, at the same time we are developing your notes, and once our polity classes are over, those notes would be available for you guys, and for that you will have to pay very little amount of money, that is only 200 per subject. For example, if you need the notes of polity, you will have to give 200 rupees. So this was in nutshell about the introduction of this video. I know that I had taken 10 minutes with this, but trust me, it would be beneficial for someone who has not seen my video yet. Now let us start with our discussion. You know, we started with the Indian Constitution. When we started, I told you what are the things we have to, we have to discuss in the Constitution. I told you, if you will look at the Constitution, if you will look at the syllabus, it says that you have to read the Constitution. You should know the Constitution. You should know what are the different laws or legislations passed by the Parliament. We have to know everything about that. But is it possible that we can know everything what is in the Constitution? Are we giving the exam of the case judiciary? Are we giving the exams for the judiciary or UPSC? So there is definitely the difference. So what is the difference? For that, I told you, you have to go through the previous year questions. Those previous year questions will give you the idea how you have to discuss these, how you have to understand, how you have to read these books. And I told you what is the material which is required for you to cover these subjects, which you can search, which you can see. If you would want to follow this initiative, you can go to my first lecture and you will find it out there. Now we had discussed the Constitution, what it is, the basics about the Constitution, how it is the grand norm, how it is the the sacred law of the land, how it is the highest law of the land. Any legislation passed by by the Parliament, any law passed enacted by the Parliament or executive, if it is against the constitutional principles, then it will be invalid. For example, we have the religious freedom. We discussed that yesterday. We have religious freedom. We have Article 25, 26. They talk about it. For example, we have religious laws which contradict with the Constitution. We saw that, for example, with respect to sati, with respect to instant triple talaq. We saw that it contradicted with the Constitution. What Parliament did, what judiciary did, they made it unconstitutional. They made it. They were totally banned in our country. So this is how Constitution works. It will have a check. It will have a check on every law. It will restrict the powers of the government. So it will give you the rights, and at the same time it will define your duties. So this is what we discussed. After that, we discussed the concept of the separation of powers, which you can go to my first lecture. You will find it there. After that, we discussed the constitutionalism, which you can find in the first lecture. And after that, in the yesterday's class, we discussed types of majorities. Majority one, simple majority, absolute majority. Then we discussed, special majorities, its types. We discussed, effective majority. We discussed everything. And during that time, I told you, whenever we just understood the concept, but we did not discuss it that much where they are used. But one thing I promised you, whenever we will move into our syllabus, whenever we will see the need of those concepts, I will tell you where the simple majority is used, where the absolute majority is used, where the effective majority is used. I will tell you where some special majority one is used, and all that stuff. So we discussed that yesterday. Then after that, what we started with the preamble. We discussed about the theme of the preamble. What is the theme of the preamble? How it acts as the philosophy of the Constitution. If you want to know what is the philosophy of the Constitution, what our Constitution stands at, you don't have to read the Constitution fully. Just read the preamble. You will get the idea what the Constitution stands at. And at the same time, I told you, this preamble does not only talk about the Constitution, but it gives us the insight of the mentality of the people who created it, who framed the Constitution. So we discussed that. Then finally we discussed what are the different themes in the preamble. We discussed theme 1, where it was talking about we the people, which is this, what is the source of the Indian constitution? It is the people of India. Source of authority, sorry, it is the source of authority is the people of India. But if we will talk about the source of the constitution, there are various sources of the constitution which you can easily read from the Lakshmikant. And if you are not ready to read that, if you want me to deliver the lecture, I will deliver a separate lecture about the sources of our constitution. And I had also added that in our notes in a very beautiful way, in a better way than the Lakshmikant, I believe so. Then we discussed about the nature of the Indian society, Indian state, through the preamble, as preamble describes us, what would be the nature of the Indian state. It would be sovereign, it would be socialistic, it would be secular, it would be democratic, and it would be republic. We discussed that, and we defined every term in a very brief way, we discussed every term in the best way possible. Then after that we started discussing the objectives of our preamble. What are the objectives of the preamble? We started with the justice, as whether it would be political, social, or economic justice. How our constitution, the framers of the constitution, had this thing in the mind that there should be the justice. The wrongs what had been done in the history, we want to right those wrongs now, and by this the preamble talks about it. And the constitution, it provides for the reservation, it provides for the equal opportunities, whether it would be respect to political or economic opportunities. We talked about how how the welfare state of our country comes in if there are any people who are out of the jobs. We discussed all that. Now today we are going to discuss the other objectives of our constitution, which are liberty, equality, fraternity, and all that. We will discuss that today. Let's move to the next slide and see what they are. Here it is the preamble. Let me again recap a few points which can be relevant to your prelims. These things are very, very sharp. Most of the times students won't even consider these things, but they may be asked in the exam. Tomorrow, actually I had seen the paper of not UPSC but JKPSC. This question was asked: what is this right sequence of these terms in the preamble? Most of the students, they will not even look at this. They won't even consider this. In this way they can ask the question. But as I told you yesterday, the first thing what UPSC aspirant should do when he is reading the preamble, he should memorize the preamble. So, and also remember that these things are not separated by commas. What does it represent? It represents that it is the integral whole. It is the integral whole. That means that it is sovereign. Our country would be sovereign. Our country would be socialist. Our country would be secular. Our country would be democratic as well as republic. It can't be we are sovereign, then we cannot be secular, or we cannot be that we will be socialist, then we cannot be secular. It won't be like that. So if what it represents, that it is a one term, it represents as an integral whole. We would be sovereign, we would be socialist, we would be secular, we would be democratic, and we would be republic. And then we discussed about the objectives. We started with what is the objective of it. We started with the justice, economic, social, economic, and political. Now today it is about the liberty, equality, and fraternity. What it is, as we are discussing right now, let me again repeat you. We are discussing the themes of preamble. First theme, it talks about the authority, source of authority, which is we Indians, we the people of India. Second, it talks about, second theme is, it is objective. What is it? Is no, sorry, nature. We discussed that it is nature is sovereign, socialist, secular, democratic, republic. Now we are discussing the third theme is objective. What is it? Is objective. What do we want to achieve? So you would have heard about the liberty, equality, and fraternity. You would have heard about French Revolution, that every citizen, they should have the right freedom of thought, expression. You should be allowed to believe in what God you want to believe. You should be allowed to worship to what God you want to worship. You can believe whatever. You can believe in God, you cannot believe in God. It is up to you. You can be agnostic, you can be atheist, you can be communist, you can be You can be Muslim, you can be Hindu, you can be Christian. It is up to you. Our constitution is not bothered about that. Our government should not be bothered about that, what you believe in. But that belief should not hurt. It should not be. That belief should not be that extreme that you will act upon that and you will cause hatred in the society. That belief will lead you to those actions. But still, the beliefs, what you believe in, you have full liberty to believe in whatever you want, but you cannot harm. Similarly, there is equality of status and of opportunity. If you are an UPSC aspirant and there is a person who is uneducated, you both are equal in front of the law. If you do any crime and he does any crime, both are convicted of same thing. There is same punishment for that. Your vote is valued same as his vote is valued. So there is definitely extreme equality. There is no, the value of your vote is 1 and the value of his vote is 1. So suppose there is a Brahman and there is a Dalit in our country. Two extremes. Unfortunately this breakdown is in our country. If we will see the value of the vote, it is equal for both. If Brahman does anything wrong, anything unlawful, and the Dalit does anything unlawful, the punishment would be same. So we are equal in front of the law. Then the third term, it is fraternity. When we got the independence, before independence, what were we? Before we got the independence, before British came here, as it is said that fraternity is the gift of the British to India. This brotherhoodness, this integrity in India. It is said that it is the gift. It is an accidental gift from British to Indians. Before British, during the Mughal era, we were divided into different kingdoms. Somewhere Marathas, somewhere Mughals, somewhere Nawab, somewhere somewhere in Kashmir there were different people. They were ruled by different authorities. So we were totally divided. We had our own ethnicities. We were divided into our own ethnicities. So what does this fraternity mean? It means that to whatever block you are in, wherever you live in, to which part of the country you live in, to what ethnicity you belong to, we Indians are the common one. We are the common one. We Indians are the one. To wherever you belong to, we are the one. There is the brotherhood between us. There is the unity between us. There is the integration of the nation between us. And if we will see how this integration was, if we will little bit discuss about it, we will see how this integration started in our country. It was, as I told you, accidentally. It was accidentally given us by the British. How the British rule started in India, then how in 1885, I guess, around that time, Indian National Congress, it came into existence. Then we saw that how Indian National Congress, it started to organize the events in which it started to educate the people about the unity. It started to educate the people about the British rule in India. We Indians were never aware of that. We were just living, we thought that they are the same as the Mughals. So they started educating us. At the same time, what the weapons British used, the ideas British used to control us, same ideas, extended. Same ideas became the reason for our unity. And this unity, this fraternity term, it is, the basic feature of our constitution. It says that we all Indians are, we are assuring the dignity of the constitution is assuring the dignity of the individuals and the unity and integrity of the nation. So these are the objectives. These are the objectives of the preamble. Now the fourth theme. What is the fourth theme of the preamble? It is the date of the when the constitution was adopted. Now, till now, I hope you had understood the preamble. From yesterday we are discussing it. I hope you had understood every concept related to it. But there are few more concepts which we had not discussed yet. I can say few facts about the preamble which we had not discussed yet. First fact, please write them as the facts. Is preamble enforceable in the court? Is preamble enforceable in the court of law? Can preamble be enforced? For example, if if the values in the preamble, for example, if their fraternity is not respected, suppose if liberty is not respected, so if the values given in the preamble are not given as such as in the preamble, when we will talk about the justice, we will see article, if we will talk about equality, we will see article 14 and 15 talking about it. So if we will talk about justice, we will talk about article 17 when against untouchability. So these are, these values of the preamble are translated into different acts. I'm not talking about those acts, I'm not talking about the fundamental rights, I'm talking about the preamble itself. For example, liberty, there would be restriction on the liberty. Can we go to the court and say, dear, dear court, as promised in the preamble, we have the liberty of thought and expression, belief, faith, and worship, and it is restricted. So please do something about it. The court will say that preamble is not enforceable. Preamble is not enforceable by itself. But what will the preamble act as? It will act as, what preamble will act as? It will act as a legal advisor. It will act as, it will aid the legal interpretation of the Constitution. Preamble, it will, preamble will aid the legal interpretation of the it will aid the legal interpretation of the Constitution. So for example, we have the cases of we had the case of right to privacy as the fundamental right. If we look at the we have this from 2007, we had under article 21, which talks about right to life and personal liberty, article 21. So right to privacy comes under article 21. Before 2017, right to privacy, it was not a fundamental right. Before 2017, it was not a fundamental right. And during that time, when Aadhaar first time came in, through an executive order, which was basically from Manmohan Singh. And when the Narendra Modi's government came in, and they passed the bill with respect to the Aadhaar, and they passed a bill with respect to it. So when Aadhaar bill was passed, there was a man, the retired judge of the Karnataka High Court. His name is K.S. Pothuswamy. He approached Supreme Court. K.S. Pothuswamy, he approached Supreme Court, said that Aadhaar is unconstitutional. So Supreme Court told him why it is unconstitutional. He said that it is violating it is impacting the privacy of a person. It is under Aadhaar, we give the biometric information which can be misused. Government can track us, government can track the people, and it can be misused. So it impacts the privacy of the person. State can launch surveillance and check your movements. We had given our information in different places. For example, our information is in banks, our information is in health centers, our information is given for the SIM cards, our information is given for the insurance. We give our information with regard to our traveling details. So for all that stuff, we give our Aadhaar cards, and it will this can be used. This Aadhaar can be used as a surveillance. A state can launch surveillance on this citizen. So it will definitely impact the privacy of the person. So this will violate the privacy of the person. So with this, the Supreme Court heard the case. They heard the case, and in 2017, in the Pothuswamy judgment, 9-member bench sat on the case, and they said that a right to privacy is the fundamental right. Now how we can connect it with the preamble? The question is how we can connect it with the preamble. You know, as we saw that the right to privacy was nowhere mentioned in the constitution, but the values, but the values which the preamble, the values which the preamble gives us, the values what the preamble talks about, the liberty of thought, expression, belief, faith, and worship, justice, whether it would be social, economic, and political, equality of status and of opportunity, and to promote among them all, fraternity, the principles, what the objectives, what the preamble gives us. It gave this idea, it gave this the legal it aided the judiciary about this legal interpretation of the Article 21, and in this the right to privacy was added. So what preamble acts as? It acts as a legal advisor to the judiciary. If there is ambiguity about any statement, it will act as the legal advisor. The judiciary will look into the preamble, what it is about, what are the values in it, and they will look in with respect to the case which is in news or which they are discussing. They will look after that case. Once they will find out, then they will give it into this, then they will give their answer with respect to that. So preamble will act as a legal advisor to them. It will act as a legal interpreter to the constitution where there is ambiguity. So another question which you can ask, which can come to your mind: can preamble increase any power which is not in the constitution? No, it cannot increase. Can preamble reduce any power which is given in the constitution? No, it cannot do that too. And also about preamble, please know that about whether preamble is a part of the constitution or not. We discussed that, but here I would also I would like to add it again. During the Bureau Boy case, it was called the preamble. It was said that it is not part of the constitution. It is just a preface to the constitution. It acted as a key opener, mind openers for the framers. But in the Keshavananda Bharati case, it was clearly said that it is the part of the constitution, because there was equal debate as when they were framing the constitution, they were framing the articles. There was debate on every article, what would be its pros and cons, whether it would be good or bad. Similarly, there was debate on the preamble also, and this debate happened after the constitution was created. So in this way, it is the part of the constitution, but it is not enforceable. So this is all about the preamble. Now one more question about the preamble which can be asked: whether it can be amended. Can preamble be amended? This is the question. About amending of the constitution, about amending of the preamble, there was a case with respect to it. Dr. Subramanian Swamy, they went to the Supreme Court. The case name is Balram Singh others versus Union of India, and Dr. Subramanian Swamy, he went to the Supreme Court. He said that preamble, it was amended during the 42nd Constitutional Amendment Act. Preamble was amended during the 42nd Constitutional Amendment Act, and the words in 1976, and the words which were added were secular. He had problem with the secular and socialist. These words were added. So he wanted the judiciary, he wanted Supreme Court to remove these words from the preamble. But what did the Supreme Court did? They did not even consider the case. They rejected the petition, and they said that, they cited that it is the power of the Parliament to amend the Constitution, as preamble is the part of the Constitution. Now about the amending the Constitution, amending the preamble. So what can we amend in the preamble? Can we amend "we the people of India"? Can we amend what is the need of amending the "we the people of India"? Can we amend the sovereign, socialist, democratic, secular republic? Can we amend justice, liberty, equality, fraternity? We cannot amend these statements because they are the basic features of the Constitution. So what is the basic feature of the Constitution? These are those features which cannot be amended. And who defines particular term or particular concept is the basic feature. It is the judiciary which defines the basic feature. It is not written in the Constitution itself that preamble is the basic feature or particular word is the basic feature. No, it is the judiciary which decides whether it is the basic feature of the Constitution or not. So these words cannot be amended. Can we amend that this Constitution was adopted on the 26th day of November 1949? Can we amend that? That would be very much absurd if we will think of amending that, because on this date it was adopted. It is not like that in 2014 we got the independence, so that would be absurd. So we cannot, if we want to remove the word from the preamble, we have to look carefully what word we are removing, whether it is the part of the basic structure or not. But we can definitely add the words in it. We can definitely add the words in the preamble. So we can definitely add the words in the preamble. So with this, our discussion with preamble is over. I hope you had got every concept related to it. I hope I was able to deliver this information very properly to you guys. Now with this, let's move to the another part. Now we will start discussing the part 1, which is union and its territories. We'll discuss with article 1. Let's move to the second phase of our today's discussion. Today's discussion, which basically starts from now, it would revolve around these important terms, which is union and its territories. We will define what union and its territories are. What does the article 1 say about it? Then we will see subclauses of article 1. We'll see article 1 subclause 1, article 1 subclause 2, article 1 subclause 3. We will discuss that. Then after that we will discuss article 2, we will discuss article 3, article 4, and finally we will discuss the State Reorganization Commission. So starting with part 1. Part 1. What does it say? Union and its territories. What does part 1 include? It contains article 1 to article 4. In India, right now there are 28 states, and 8 union territories. And one thing you should remember, that this part 1, it majorly is about, especially article 1, it is majorly about what? It is majorly about states. It is majorly about the state. Its focus is on the states. That we will understand how. So when we got the independence, when we achieved the independence, and the Constituent Assembly was framing the Constitution, so there was a huge discussion. About the name of our country. What should be the name of the country? Some were in the favor of India, some were in the favor of Bharat, there were different names for it. So there was no consensus over it. And also at the same time, there were various doubts with this regard. First with respect to name. Second, it was the time when Pakistan was bifurcated from India, when India was divided. It was that time. So the unity of India was in danger at that time too. So many things were considered for every word what they used in the Constitution. There were huge discussions about it. Here, as the federal nature, we will see how the federal nature would come into the picture when we will discuss article 1, how the questions were raised to the Ambedkar. So when all these discussions with respect to name, with respect to the statements, with respect to the words which were used, so then came the first article. Now we will see what does the first article say. First article says India. It says India, and that is Bharat. India, that is Bharat, shall be a union of state. Shall be a union of state. So why India, that is Bharat? Why they went for this name? As I told you, there was no consensus, because some wanted that India should be the name of our country. Some wanted that Bharat should be the name of our country. Why should we adopt the name of the what Britishers called us? Why should we adopt that name? Some believed in the socialistic nature of our country, that it should be named in that way. Some had different ideas, some were very much pro-Hindi, and the southern states, they had different ideas. So there was no proper consensus with respect to the name of the country. So what did the constitution makers did? They tried to satisfy everybody by calling our country as, by naming our country as India, that is Bharat. India, that is Bharat. So this part is understood. I hope this part is understood. Then the second term in it, the second phase in it, India, that is Bharat, shall be the union, shall be the union of states, shall be the union of the states. So this part, there was again discussion over it. So we saw that, we discussed it from last few days. We are discussing that the federal nature of our constitution. We discussed that how a constitution can be federal. We discussed that what are the conditions it should satisfy. We discussed all that stuff, how it should be in parallel with whom, how it should be in parallel with the constitution of USA. We discussed that what were the important features of the federalism. Federal constitution, it should have a dual government. We had the dual government. It should have the written constitution. We should have the separation of powers should be there. The judiciary is independent. All that which we had discussed. So question was raised to the Dr. Ambedkar. They said, sir, by naming it as union, by naming article as shall India, that is Bharat, shall be a union of state. By naming it as a union of state, what do you mean by that? What do you mean by that? What is this union of state? Are we not the federal institute? Is our country not a federal country? Is our constitution not a federal constitution? So what it is, what it is about, why we are naming that, it should, as mentioned in the article, that shall be the union of the states, that India, that is Bharat, shall be a union of states. What do you mean by the union? This question was asked to the Dr. Ambedkar. So Dr. Ambedkar answered it. He was very intelligent man and very educated man. He answered it in a different way. There are many reasons why they chose this word union for us, why they did not choose federal, but they chose union. Let us discuss what was the answer given by the Dr. Ambedkar. He said that India is not a result of an agreement between the states. What he said, that India is not a result of an agreement between the states. Like in USA, the states, when they got the independence from there were 13 British colonies in the North America. When they got the independence, they said together, they decided that why not we join together, why not we come together and join together and frame a constitution for ourselves and grow together. So in this way, Indian situation was not like that. India was not formed. India did not become India because different states came together. India was an integral whole. India was an integral whole. You can now argue that, sir, there were many princely states which came to join with India. But your statement will have the answer. They came to join with India. There was, they did not came to create India. They came to join with India. So India was not a result of an agreement between the states, which is the proper, which is the basic. As we know that there is no proper definition of the federalism. If we look at the highest picture of federalism, we have to look at the US's constitution. And what does the US's constitution say? That federalism should look like that. The states would come together, they will have an agreement. But in India's case, it was not so. Indian states did not come together, they were holding together. So that is why we say that Indian federalism is because of the holding together. It is not because of the agreement between the states to come together. We hold it together always. But there came some princely states that was different. They joined us. They became part of us. For example, Sikkim, they joined us. Tomorrow, maybe Bangladesh will decide that we will join with India. They can join us. We have different articles for that, which we are going to discuss in a meanwhile. Tomorrow, Pakistan can think that let's join together. They can join us if we want to. So this is a joining is something different, holding together is something different, and coming together and making a country, that is something different. So in India's case, according to Ambedkar Sahab, we did not, our states did not have any agreement. It is not, India is not because of an agreement. Second thing which he highlighted, that if, for example, if states are coming together, there are always chances that they can get out of the agreement. But in India's case, states cannot secede from India. No state can secede from India. There are claims from, there are chants of independence from different states in India, but can they achieve that? They will never achieve that. It is impossible for them to achieve it. So this is that they cannot secede from India. Then the third important point, why it is used that it is the unitary, why unitary word is union is used. This is also discussed. The reason for that is, it was a time when India and Pakistan had bifurcated. It was a time when the integrity and unity of the country was under huge question. So they did not want to give this idea to the people. The framers of the constitution did not want to give this idea to the people that we are a federation and you can secede at any time you want. So this, to play a psychological game, to give this psychological understanding about the country, that we are a union, we are unbreakable. Nobody can break us. Nobody can take Kashmir away from Kashmir. Nobody can take Punjab away from Punjab. Nobody can take Northeast away from India. So that Kashmir out of India. So this was a statement, and for that they could, federal state word was not more proper to be used. So they used what? They used the word which is union of state. So these were the important things, which were very important for us to understand why these words, why India, the Bharat was used. There was no consensus. Can we tomorrow can we change the name of India into Bharat? Exactly, we can change it, but for that we have to inform UN. Now you can ask, sir, why do we have to inform UN? What is the reason for that? If you want to change your name, there is no issue, but there can not be two persons having the same name. For example, can we name our country as China? So for that purpose we have to go to UN. We have to ask them that we are going to change our name. So that we can do. Even both India and Bharat, it is the name of our country, as the as the Supreme Court is very much clear about it. There was some people went to the Supreme Court and they told them that, sir, please change the name of India to Bharat. Supreme Court rejected the case. It rejected the PLI, which was PIL, which was which was filed, that it is already the name of the India. It is India as well as Bharat. So till now, I hope you had understood it. Now moving to the second part of Article 1, which is Article 1 subclause clause 2. So what does it say? It says, the states and territories thereof shall be specified in the first schedule. For example, there is a state, Jammu and Kashmir. Jammu and Kashmir is a state. Punjab is a state. At that time it used to be state. Jammu and Kashmir used to be state. Punjab is a state. Tamil Nadu is a state. So these are the states. And what does the Article 1 clause 2 says? The states and territories thereof shall be specified in the first schedule. First let's understand what the schedule is. Let's understand first what this schedule is. This schedule is just the explanatory memorandum of the article. It explains the article. It further describes the article. For example, Article 1 says Jammu and Kashmir. Schedule 1, in the schedule it would be represented that in J&K, what is its territories, all that, what is the area under J&K, that would be represented. So it is the schedules are the explanatory memorandum of article. And we add explanation at the end of the constitution, so to mention these. So in the article 1.1 subclause 2, what does it say? It says that the states and territories thereof shall be specified in the first schedule. What is their area? What is the area it contains? All that stuff should be the demography of that particular region. It should be not demography. The area it should be mentioned. The details of the state it should be mentioned there. Then comes Article 1. Article 1 subclause 3, the third subclause of Article 1. So first let me repeat, let me rub it. So till now I hope you are very well with Article 1, Article subclause Article 1 subclause 1, Article 1 subclause 2. You are very much aware of it. I hope so. Article 1 subclause 1 talks about the name of the state and the nature of the state, which is India, that is Bharat shall be a union of state. That I hope you had understood. Article 1 subclause 2, it talks about the states and territories thereof shall be specified in the first schedule. What is schedule? You would hear often about the schedules. What is schedule? It is the explanatory memorandum of article. It explains the article. For example, Article 1.2 talks about the states. What is the area of the state, that would be explained in in the schedules, in the first schedule. So Article 1 subclause 2 says the state and territory thereof shall be specified in the first schedule. Now here let me write it. You are done with Article 1 subclause 1. You are done with Article 1 subclause 2. For Article 1 subclause 2 you need first schedule. So please remember that, first schedule. Now what is Article 1 subclause 3? What is Article 1 subclause 3? It says the territory of India shall comprise of the territories of the state. It talks about now the territory of India. What does territory of India? What does territory of India comprise of? It says Article 1 subclause 3, it says territory of India will comprise of the territories of the state. Territories of the state. What are the territories of the state? Second, the union territories specified in the first schedule. The first schedule will specify the union territories. Union territories specified in first schedule, it will talk about that. And such other territories as may be acquired. Such other territories as may be acquired. So Article 1 subclause 3 talks about the territories of the country. Article 1 subclause 1 talks about the name and the nature. Article 1 subclause 2 talks about the state and territories thereof shall be specified in the first schedule. Basically it talks about the first schedule. If there is any state, its territory should be specified in the first schedule, and also about the union territory. Article 1 subclause 3 talks about the territory of India. What is the extent of India? It talks about the territory of the states. It talks about the union territories specified in the first schedule, and such other territories as may be acquired by India or succeeded to India. For example, under this we have the example of the Puducherry, which used to be the Pondicherry. In 1954 it was succeeded to India by the French, and until 1964 it was administered as an acquired territory, till 1962. In 1954 Puducherry, it was succeeded to India by the French in 1954. But till 1962 it was treated as an acquired territory, For example, in Article 1 subclause 3 we have third section in it, that such other territories as may be acquired. So this acquired territory, it was till 1962 Pondicherry was given the status that it is acquired territory. So with this I hope you are done with Article 1. You had understood every concept related to it. Now let's move towards the Article 2. What does the Article 2 say? Let's try to understand that. So here let me repeat one thing. So you are done with the schedule 1. What does it talk? It talks about the territorial extent of the state or the union territory. It is discussed in the schedule 1. Now article 2. What does article 2 talk about? It says admission or establishment of new state. Parliament may by law admit into the union or establish new state as such on such terms and conditions as it thinks fit. So what does article 2 say? Parliament may by law Parliament may by law admit into the union. They can admit into the union, into the union, or establish new states on such terms and conditions as it thinks fit. So Parliament, they can establish, can admit into the union or establish new states. They can admit into the union from the outside, or they can establish new states on such terms and conditions as it thinks fit. So what does it say? Let's take an example of this Sikkim. Sikkim, you would have heard about it. It was not always the part of India. It was not always the part of Union of India. Not always. Before 1973, before 1974, it was ruled by a hereditary ruler who was called as a Chogyar. He was called as a Chogyar. Earlier, before independence, it was part of the India. It was very much part of the India. But after independence, they stated that they would want to stay away. And Sikkim was the protectorate of India. It was protectorate of India, that India would protect it diplomatically, it will protect it militarily. So India will protect its territory. But as time passed from 1947 to 1973, there rose a revolution, we can say, or we can say spring of 1973 in Sikkim, when people got educated and they wanted to overthrow this monarchy rule, and they wanted that they should be ruled by the democracy. So with this regard, when there were protests everywhere in the Sikkim, so India interfered. The protesters and the Sikkim, and the Chogyar, they sat down and they decided that there would be an election. The Chogyar would be the nominated head, like the Queen of England. He would be the nominated head, not as strong as her, but he would be the nominated head. And there would be the proper elections. So during this time, during the elections, what happened, that pro-India government, they won the election. Now when the pro-India government won the election, it was a time when Indira Gandhi was the PM of India. She passed the 35th Constitutional Amendment Act. What she did, she passed the 35th Constitutional Amendment Act, and she passed it in 1974, and she admitted Sikkim as an associate state. Associated state. So to this, there was a huge retaliation against Mrs. Gandhi. There were questions raised against Mrs. Gandhi that if you wanted to add the Sikkim, you could have added it directly as a state, because it is very much clearly mentioned in Article 1, subclause 3, that such other territories as may be acquired, like we acquired Pondicherry, we could have easily acquired the Sikkim. But why this constitutional amendment? There was no need of the constitutional amendment. She was very much clever with respect to that. She knew that if she will remove the Chogyar right now, the people will raise questions against her. She would be considered as dictator. So she did it very intelligently. So during that time, when it was as an associate state, and when this constitutional amendment, 35th Constitutional Amendment, was passed, there was a new subclause in Article 2, which is Article 2 subclause A. Article 2 subclause A, it was added, and it gave the associate status to the Sikkim. But after this, there was a referendum in the Sikkim that whether you want to be independent or you want to join India, and most of the people in that region in Sikkim, they voted in favor of India, and they wanted to be the proper they wanted to achieve the proper statehood of India. So they achieved it, and then there came the 36th constitutional amendment was passed, and Article 2 subclause A, it was repealed, and Sikkim became the full-fledged state of India. So what is the crux of the Article 2? Crux of the Article 2 is it gives the Parliament the immense power that they can admit into the Union, or they can establish new state. For example, there is some Union territory. Tomorrow, suppose they want to change the status of Union territory of Jammu and Kashmir. They want to give it the statehood back. How they will do it? They will do it through Article 2. They will do it. They will change it. They will change the status of. They will change it. They will give it the status back. They will make it again. They will make it what? They will give it the statehood back. So this is all about Article 2. Now, one thing I want to highlight here. For example, suppose tomorrow they are going to add Bangladesh. Let's suppose Bangladesh will decide to be the part with India. They would decide that they want to be the state of India. They are fed up with their government, and they think they cannot do anything of their own. They want to join India, and they will join India through Article 2, and that we will acquire them. So how it will impact our constitution? So first there would be need of some amendments. First there would be the need of the amendment with respect to the Schedule 1, because the territory of the Bangladesh, whether it would be added, there would be the addition in the Schedule 1, and at the same time there would be addition with respect to the Schedule 4. So Schedule 1 and Schedule 4 would be amended. Now the question is, would it be considered the amendment to the Constitution? That we will answer after we will discuss Article 3 and Article 4. First, let's move to the Article 3. It was premature to discuss it here, but let's keep it in the mind. Just keep it in the mind. What are the impacts of it? How it can change the nature of Schedule 1 and Schedule 2, and is it considered the amendment to the Constitution? Do we need Article 368 for it? That's what the real question is. Now, the question. Now we had reached to Article 3. What does Article 3 say? It gives the immense power to the. It gives immense power to whom? It gives immense power to the Parliament. That's why we say that sometimes we have the centralizing tendency of the Indian federalism. So Article 3 says Parliament may by law, if they want, they can split a state, like they did with respect to Andhra Pradesh into Telangana and AP. They can unite the states. Under this act. They can change the area of this. They can alter the area of the state. They can increase it or decrease it, change the area, and also they can change the name of the state. And who has this authority? This authority lies within the Parliament. They can do it by simple majority. By simple majority, we discussed yesterday what simple majority is. What are the members present and voting? 50%, more than that, and a majority of 50%, above than 50% is the simple majority during voting, who are present and who are voting. So that's very much clear. So this can be done through the simple majority. Now let us see how it is actually done. For example, in 2024, Andhra Pradesh, it was bifurcated into Telangana. So Telangana demanded that that we are getting least importance with respect to the mainland, mainland Andhra Pradesh. They are getting the resources, they are using them, and we are being ignored. So they request that they should be given separate statehood. Now let's see how this bill will be passed. Such bill, it would be first this has to be done by the parliament. So first, union cabinet will discuss the bill and they will clear the bill. Union cabinet will clear the bill. First cleared by the union cabinet. This bill would be first cleared by the union cabinet. Then it would be introduced. Bill would be introduced in parliament. Bill is introduced in parliament. It, with the permission of president. This bill cannot be introduced in the parliament without the permission of the president. So please remember that. Once the bill is introduced in the parliament, in which house it should be introduced? It depends where you want to introduce it. You can introduce it in the Lok Sabha, you can introduce it in the Rajya Sabha. So with respect to Andhra Pradesh, it was introduced in the this bill was introduced in the Lok Sabha. So after this bill is introduced, when the bill is passed by the simple majority, it will go to the president for his signature. But before president will sign on it, what he will do, he will send it back to the Andhra Pradesh, because Andhra Pradesh is involved for this state legislature is involved for that, and president will ask his consultation. What do you say about it? Remember one thing here, that the consultation of the state is not binding on the president. It is not concurrent on the president as used to be, as it was with J&K before Article 370. It is not concurrent. It is not binding on the advice of the AP of the state is not binding on the president. The Andhra Pradesh said no, they don't want it, but president was very much ready to do it. So he signed it, and then act became. Then the Andhra Pradesh was divided into Telangana and Andhra Pradesh. So this is how this procedure is done. Now let's take an example of the Jammu and Kashmir. The case with Jammu and Kashmir is totally different, because the case how it was, how the statehood was removed, was revoked for Jammu and Kashmir. It is something different, and the case definitely needed the insight from the courts, from the Supreme Court, and they gave it with respect to their, whether you like the decision, that is some different topic. So what happened in Jammu and Kashmir? Jammu and Kashmir, J&K, till 2019, they enjoyed the special status. Special status that was due to Article 370. What was this special status? It said that only Article 1 and Article 70 is applicable to Jammu and Kashmir. Automatically applicable. Only Article 1 and Article 70, Article 370 is automatically applicable to Jammu and Kashmir. For rest, you need the concurrence, you need the approval from the Jammu and Kashmir Assembly. So this is what it stated. And about Article 3, it was not applicable in J&K, because for the Article 3, as we saw with respect to the Andhra Pradesh case, Andhra Pradesh State Legislature Assembly, they said that they did not want the bifurcation, but that was not binding on the president. But with respect to Kashmir, if the central government wanted to change the status of the Jammu and Kashmir, they could not have done that, because if J&K Assembly did not agree with them, so if they did not agree with them, then they could have not done it. The decision of the J&K Assembly was binding, was concurrent on whom? On president. So that was the difference. Article 3 was not applicable in J&K. So what did the government do? They revoked the Article 370. They nullified it. Now what all the constitution of Jammu and Kashmir is applicable to J&K. And finally, as we know that it was a time when J&K, it was under the presidential rule, because the PDP government and the BJP government, they had the alliance, and that alliance was broken, so it was under the presidential rule. Now we know that when the state is under the presidential rule, it is actually the parliament which is making decisions on behalf of the state, which is actually which has control over the state. So what they decided, the central government decided that they would want to revoke the status of Jammu and Kashmir. They want to bifurcate it into union territory and into the union territories. So they followed the Article 3. What was the procedure? Same was followed. First, the Union Cabinet discussed it, then it was introduced in the Raj Sabha, then into the Lok Sabha, then it went to the President. When the report went to the President wanted to consult the State Legislative Assembly, but it was under the presidential rule. So what did the President do? He believed that it is the time when it is under the presidential rule, so it is the Parliament who will decide on their behalf. So he sent a proposal to the Parliament, and Parliament agreed. Then President signed, and the status of Jammu and Kashmir was changed to the Union Territory of Jammu and Kashmir and Ladakh. Now the case went to the, it was done like that. Now the case went to the Supreme Court. There were various questions asked to the Supreme Court. If you would read about it, you will find out that Supreme Court in a way did not answer many questions. First thing, there was question about the federal structure. In first schedule we have to write down the territories, who are the territories of India. The states, their territories. You can definitely carve out a union territory, but totally ending the statehood, which is the federal structure of the country. Can you go against the federal structure? Can you go against the basic structure of the Constitution? Can you go above the basic structure of the Constitution, to which the Supreme Court did not answer. The Supreme Court said, if such matter appears again, we will answer them. Right now they are going to give the statehood back. So what, as the Solicitor General, he has argued that he has promised that the statehood would be given back to Kashmiris. So there is no need to discuss it right now. Then the second question which was asked, can Parliament change the status of the state to UT? Can they change it? Can they change it? Change the status of the state into UT? This question was asked, and also the question which was asked was, can Parliament give views on behalf of the state legislature? They can control the state legislature when there is a parliamentary, for a presidential rule. But can they take such decisions which is going to impact the statehood, which is going to impact the overall integrity of the state? Can they take such decision? So these questions were asked to the Supreme Court, to which the Supreme Court replied that if such incident will happen, they will take the consideration, but still they will give the statehood back to them. So there is no need to discuss it. So this is about Article 3. Now let's move to our first question. These were, as we will jump to our first question, which I asked you about the first schedule and the fourth schedule, what they are about, the constitutional amendment needed. Before we will discuss that, I would like to conclude the Article 3, what it is about. This Article 3, it gives certain powers to the Parliament, which makes it in a way very much sovereign in decision making. For example, it can split a state. It gives it shows the centralization tendency of our Constitution, that it can split a state, it can unite the state, it can alter the area of the state, it can change the name of the state, it can bifurcate it. So this is what is about the Article 3, and we discussed how Andhra Pradesh was done, how statehood, how this carving out of a state is done, how the state can be bifurcated. There, President asks President can refer it to the said legislative assembly, which is under discussion, and they can respond to it, but that is not binding on the President. But we saw how with respect to Jammu and Kashmir it was done, but there are certain questions. For example, with respect to federalism, as it was challenged, the statehood of Jammu and Kashmir was totally degraded to union territories. As state, it is the federal nature. There were the sharing of funds, sharing of powers. It was the federal nature. It is very much federal, in nature. So this was reduced. So there was definitely the question with respect to that, whether it was the basic, whether, as we know that federalism, it is the basic structure of the constitution. How could center do that? To which the Supreme Court argued that they are not, as they are promising that they are going to change the status of Jammu and Kashmir very soon, they will give the statehood back, so there is nothing to worry about. And if such incident happens again, they are going to take the case and discuss about that. Now let's move to the Article 4. Before we started Article 2, I told you there are few things. For example, we discussed about Schedule 1. It would talk about the territories. Schedule 2, Schedule 4, it will talk about Schedule 4, it will talk about the representation of states in the Rajya Sabha. For example, Schedule 1, it will talk about the names and territories of states and UTs. J&K, for example, it would talk about J&K. Here it would talk about what are the number of members from J&K who would represent J&K in Rajya Sabha. Suppose it was 4. After Article 2 and once Article 2 and Article 3 is used, for example, we acquire some state, we acquire Bangladesh, there is a change in Schedule 1 and there is a change in Schedule 2. For example, they would be given 5 representation. And Article 3, it is changed, we changed the status of Jammu and Kashmir to Union Territory. Ladakh was removed from it. Now the status of the Schedule 4, it is reduced from 4 to 1. So there is definitely change, and schedules are very much part of the constitution. So the question is whether it would be considered the constitutional amendment, whether it would be considered, whether it would be done under article, whether it would be considered the constitutional amendment as it is done under Article 368. The constitution, when the constitution is amended, that is done under Article 368, and you need special majority for that. Would it be considered same? The Article 4 defines this. No, it will not be considered same, because it is not considered as an amendment. Laws made under Article 2, Article 4 says laws made under Article 2 and Article 3. They are not considered. They are to provide for amendments of the first, and when we make laws under Article 3 and Article 4, there is definitely the need of the amendments in first schedule and the fourth schedule and fourth schedules. And they are they need to be supplemented, or something needs to be reduced, so definitely they are amended. But this amendment, it shall not be deemed as an amendment to the constitution as under Article 368. This amendment is not it should not be deemed as an amendment as under Article 368. If you do any changes under Article 2 and 3, this is not considered amendment as is done in Article 368, because for Article 368 to amend the constitution you need special majority, but here it was done through the it can be done through the simple majority. If you want to change the name of the state, you can do it through the simple majority, or you want to change the status of the state, you can do it through the simple majority. So this was about the union and its territories. Article 1 we discussed that in detail, Article 2 we discussed that in detail, Article 3, Article 4 we discussed that in detail. So I hope there is no confusion left. What Article 1 says, the name of the country, the nature of the country. Then Article 1 subclause 2, it talks about the states and territories thereof shall be specified in the first schedule. Whatever the states we have, whatever the territories we have, they should be specified in first schedule. Then we have Article 1 subclause 3, it talks about the territory of India shall comprise of, it talks about the territory of India. Then finally we will discuss it about Article 2, it talks about Parliament may by law admit into the union or establish new states on such terms and conditions as it thinks fit. Then we discussed various examples. Then we discussed Article 3, how it grants the Parliament the power to split a state, to unite a state, to increase the area, to decrease the area, or to change the name of the state, and how it is done. We discussed that too. Both are done through the simple majority, and if any changes are done through the Article 2 and Article 3, the changes are specified in Schedule 1 and Schedule 4. We saw that Schedule 1 it gives about the names of the territories or states. Schedule 4 it talks about the representation of the states in Rajya Sabha. So there definitely is the need of the change of these schedules. So under Article 4, what it states that whatever change is done under 2 and 3, it will not be deemed as the constitutional amendment as it is done in Article 368, because for the Article 368 we need special majority. So till now I hope everything is fine. Now let's move to the last part of our today's discussion. Very simple. We'll try to conclude it in few 5 to 10 minutes, and then we will end our today's discussion. Then we will solve our questions and our discussion. Now it is State Reorganization Commission. So it is the reorganization of states after, we needed, when we got the independence, there was a need of the reorganization of states, reorganization of states, states after independence. There was need of that. When India got independence in 1947, there were 4 types of states. Part 1, 4 types of states were there. For example, Part 1, it contained the states like Bombay and Madras, as they were under the control of Governor General. So these were the Part A states. Then we have Part B states. What were these states? These were the princely states like J&K, Mysore, Hyderabad. They were the princely states. Then we have Part C states. We have states like Delhi, Coorg. They were under the Chief Commissioner. Part C states were those who were under the Chief Commissioner. Then we have Part D states. It included only Andaman and Nicobar Island. So these are this was the category of states with respect to it. Then there was a need of the reorganization. So with respect to this, after independence, there was demand to create states on the basis of language. So for that, different commissions were created. For example, first commission was Dar Commission. It was created in 1948, and it was asked to look at the situation and see and make a report about whether a state should be created on the basis of language. To which the Dar Commission replied that please don't do this mistake. We can't bifurcate. We had already bifurcated. We had been already divided because of the religion. We can't be divided on the basis of language. So Dar Commission was the first commission which was created with respect to it, and it recommended that it should be done on the administrative ease. On the administrative ease, the state should be created, not on the basis of language. Then after that, there was continuous demand from various states that the statehood should be given them on the basis of their language. For example, Andhra Pradesh, they were Telugu speaking, so it was continuously there. Then after that, another committee was created, JVP committee, in the same year 1948. In the month of December, they also highlighted the same. It should be the state should be created on the administrative ease, but not on the language. So at the same time, there was challenges coming from the South Indian states that, especially the Tamil, Andhra Pradesh, that they should be given the statehood on the basis of the languages. During this time, there was a person, Poti Sriva Mullah. Poti Sriva Mullah. Poti, please do remember the name. Sri Vamullah. His name is Poti Sri Vamullah. He was on the fast. He demanded that they should be granted the Telugu speaking state. All the Telugu speaking regions from the Maharashtra or Tamil Nadu, they should be given a separate state named Andhra Pradesh. So he died. The state, we were not ready to give them. The center was not ready to give the statehood like that, but he fasted till death and finally died. And finally, the government was under pressure, and it was the first time, first linguistic state was created, and it was Andhra Pradesh. Andhra Pradesh. As Andhra Pradesh was created, so definitely demands, many states, they started demanding that same should be given to them. This same opportunity should be given to them. So there was definitely the need of the State Reorganization Commission. So to overcome those demands coming from different regions, State Reorganization Commission was created, and it was headed by three-member committee headed by Fazl Ali, H.N. Kunzru, and K.M. Panika. Fazl Ali, H.N. Kunzru, and K.M. Panika, they headed in 1953, and they discussed about it, and finally they gave the report that yes, it is fine to make a state on the basis of language, but there should be but one state for whole Hindi speaking. It won't be easy, because if we will look at the North India, every region is speaking Hindi, so we can't make it a one state. So there is no big, for the bigger states there is big no, but you can create some states on the basis of language too, and it would be preferable to go for the administrative convenience with respect to making of the states. Keep the language also the criteria, but major perspective, major focus should be on the administrative convenience. So by this, different states came into existence. For example, after this, the State Reorganization Act was passed in 1956. In 1956, State Reorganization Act was passed in 1956, and 14 states and 6 union territories came into existence. And finally, this bifurcation of states, it was very, very continuous. For example, Chhattisgarh came out from the MP, Jharkhand came out from the Bihar, so it was the continuous process. So till now we have 28 states, but the question is, there is always the demand of the separate states. And if we look at this, we can ask a question to ourselves here, that is it good to have a smaller states and maximum number of states than having a bigger states? What would be preferable? What is preferable for us? For the administrative ease, is it good to have a smaller in area, smaller but maximum number of states? For example, if we take the example of USA, they have 50 states. Why can't India have the 50 states? Why can't we have the 60 states? It is not something written that a country should have least number of states. It is good for the administrative purpose, but if you are not able to go for the proper administration of the states, if you are not able to manage the states properly, then why not bifurcate them? So there are demands from the various states. For example, in UP there are demands that it should be bifurcated. In various other regions, in West Bengal there is the demand for the Gorkha land. In Manipur there is the demand of Metis, they are demanding the UT status. So definitely there are various demands. Now the question here comes, does this smaller state be more prosperous? We can see the example of Goa, which is the smallest state and it is the most prosperous state in India. And we can see the states which came out from the bigger states, they are doing better than the bigger states. We are seeing Uttarakhand, who came out from the UP, they are doing better than the UP. So definitely, when the states are smaller, the distance between the capital and the people is very small, and they can speak their problems to their leaders, and they are, it becomes easy for them to govern. But with respect to the bigger states, it is something, it is an issue. Now the question comes here, does it only have the advantages associated with it? No, it will have some disadvantages too. It can threaten the integrity of the nation. It can increase the expenses. It can, we are a diverse country. We have huge diversity in the country, and it can impact the diversity of the country. So there are both cons and pros with respect to that. Now the question, another question which I should ask you, which can be asked in the exam, is there the need of the another state reorganization commission, which would discuss the needs of these states, whether we should create it or not? So please, if you are watching this video, do write this question in 250 words. Is there the need of the second reorganization commission? So this is the question for today's discussion. So till now, I hope you had understood everything. With this, we will conclude our discussion. Now let us try to solve the possible prelims questions which we had brought today. Then we will conclude our discussion. First question, it says, which of the following statements correctly describes the preamble of the Constitution of India concerning its enactment, constitutional states and enforceability? It says it was enacted by the Constitution Assembly, correct. It is part of the Constitution, correct, and is non-enforceable by the courts, correct. So the answer is option A. Now let's move to the second question. It says, consider the following statements regarding Article 1 of the Constitution of India. First statement, India, that is Bharat, shall be a union of states, correct. Second statement, the territory of India comprises the territory of states, the union territory, and such other territories as may be acquired, as we discussed in Article 1 sub clause 3. So this is also correct. So with respect to this question, the correct statement is option A, that is both A and B, both 1 and 2. So with this we complete our today's discussion. So please do subscribe the channel, do share it with your friends, and please do write in the comments what do you feel about the initiative. Thank you for staying with me. Thank you very much and have a nice day.